Hi, Zachary Ashby at Pacific Northwest Family Law. One of the things that we do a lot as attorneys is help our clients through mediation. So I wanted to do a quick video on mediation prep so that you know what to expect, because every family law case in Washington, um, just about everyone, goes through mediation at some point. Mediation itself, there's a few things that you can do to prepare for mediation. First one is to gather information. The formal process is called discovery. Through discovery, you can demand documents from the other side. You can make the other side answer questions under oath. If you need to, you can interview witnesses in what's called a deposition and get their sworn testimony. All under oath and very official. Usually, what that means is before you're even going to, before you go to trial or before you go to mediation, you know everything you need to about the finances, the ability to parent, the debts, the income, everything. Even the stuff that the other spouse didn't want to tell you, because through the courts you can require them to tell you all those things. And so it's a very involved process, but it's an option that's open to everyone. And of course, that's something that we do regularly as attorneys to get people through and gather that information from the other side, so that we're thoroughly informed about everything that's going on the other side, including witnesses and everything. And usually we have more or less a strategy about how we're going to conduct the trial even by that point, because we know we have enough information. The next part is what's called a Batna. This is a technique that was developed a long time ago. It's not by me, but it's an acronym that stands for the best alternative to a negotiated agreement. And what that means is, for family law, you should have an idea of what the court would order given the facts that you know. That's why getting that information is the first step and starts months in advance. So you have all that, you can prepare, you can analyze it, and then you know, given all this information presented in the right way, what's your best at court, what's your best day? Okay, so then you know what that is, and then you need to know, well, if I don't get my best day, what's the opposing party's best day? What can they get? And that sets your range. So then you know that's how you set your expectations for mediation, so that you can gauge the reasonableness of your own offer and of the opposing party's offer, because you know you have an idea of how the court will come down. And in family law, unlike other areas of law, there's a great deal of flexibility that the court has. So it does require you to know how the actual judges in any given county rule on different issues, how they conduct themselves, what their ideas are, and even biases are when going into a trial. Now, I will tell you, most family law cases reach an agreement at mediation. They're not always the best agreement, and you have to be prepared to compromise some of your best. No one gets their best day. Usually, well, almost no one gets the very best thing even at court. And so you have to temper it with what the other side can get. In the court, when you go into court, the judge is going to come down probably somewhere in the middle. Most judges try and be very fair and even with both parties when it comes to assets, debts, time with the children, and everything. And so having that information, knowing that ahead of time, and how the court would react, helps you to gauge your own offer. One thing I left out of this is that you can then would prepare. What we do for our clients is prepare we call it a position statement, but it's basically where we're at going in. It's really an opening offer. It sets the groundwork so that the other side knows what we want. And usually we set that according to this BATNA. It's all part of the process. Some information we might keep back from the other side so that the mediator knows a little bit of the background and the reasoning behind what we're asking for, and the mediator will keep those things confidential. But then when the mediator goes to the other side to get their reaction, they'll be able to better gauge when the other side gives a counteroffer what the reasonableness of the counteroffer is, and work with them to give us a reasonable offer. I mean, the bottom line is by being prepared with 1 and 2, we're controlling the dialogue before we even get to even start mediation. So that's why it's important to be prepared and have a plan going in. The next thing, when you're prepping for mediation, especially the day before, rest up. Mediation is long, it can be stressful. Don't go into it tired so you're not making a bad decision on the day of, because you're going to be asked to give up certain things, to change and to agree and negotiate and consider the other side's part, and whether it's reasonable or how your chances are at court before a judge, whether those chances are worth the costs of trial. And I'm not just talking emotional or financial costs, but the emotional costs, because trial itself is like 10 times more stressful than mediation. And at trial, you don't get to decide what the outcome is. The judge is deciding what the outcome is, so that it is taken out of your hands. Mediation is usually one of the last times where you can control how things shake out. And it does require it does require both sides, not just you, but the other side as well, to compromise on certain things and reach an agreement. Now, all of this leads up to what your strategy is the day of. Again, we like to send over a position statement ahead of the mediation so that we're controlling what's going on. Usually we try and, because we have the information, because we've discussed what the best alternatives are to negotiating an agreement, we know the range of what a judge would rule given the information. We're prepared, and we know more or less what our strategy is going in, so we can know what are the areas where we're willing to negotiate, where we're not. We often talk, I've walked away from mediations before because the other side is just so unreasonable, comes out of left field, that we say, well, we're not getting anywhere because that's just ridiculous, and we pack up and go home early. I've also had mediations that go twice as long as what we schedule because we're both within the realm of reasonability and we're both progressing, but the progress is going slowly towards one way or the other, and we stick with it because it's better to go long on mediation than to risk going to trial, because there's a risk for both sides that you're not going to get as good of a result as what you can negotiate, because even though you can predict a range of outcomes from what a judge might give, it's uncertain exactly what the judge will give, because there's a lot of things that go into all considerations. So you have to be prepared for that. So that's really a day of. Now, most mediations, when it comes to family law, and usually what I found to be the most successful is that you are not in the same room as the opposing party, that you and your attorney are in one room, and your soon-to-be ex or your ex is in the other room with their attorney, and the mediator will go back and forth. This allows you to be a little more candid. It allows you to react emotionally to anything the other side says without showing emotion to the other side. It then allows you to be a little more rational. There are some difficult things. You can get cheaper mediation. At some places will offer a mediation where you sit down at the same table as your ex. I think that's a bad idea, just because usually you have in relationships that are ending, you already have a power imbalance, and because of either just the other person's more intimidating or more bullish or hard to deal with, and going in and sitting across a table with them, I mean, a mediator can only do so much, and the other person will say things that the mediator won't pick up on because they don't have a history of that relationship with them. And being across a table, it can sometimes be harder to look them in the eye and say no, which is an important part of mediation, being able to say no to the wrong things, and yes to the right things. So all of this is part of developing your strategy going into mediation, and all the things that we do with our clients to make sure we get the best chance at a good resolution. If you have any comments or questions, please comment on the video, or you can send us an email, info@pnwfamilylaw.com. You can always call us at 509-866-4111. Subscribe to our channel. You'll see more videos. We're trying to do lots of these this year. And if you want a specific topic, please let us know, and we can do videos on those. Thank you.